Okay, thanks for this question. Well, first of all, I'm happy that it begins to be understood now that there will be no three-strike rule, and I suppose that you will change the information you spread accordingly, because you have said everywhere that there is going to be three-strike rule. I say no.
You said that they would be induced, not imposed, all the time.
Okay, well, that will be induced. It will not be induced neither. That is very clear. And, well, you can have it both ways. I mean, if you ask the questions, you have to believe the answer. If you don't believe the answer, why ask the question? So the answer is very clear. It will not be induced. And if you look at our acquis communautaire, we will strictly respect that, including the exemption of liability for ISPs, etc. This is what you're referring to. As to the statutory damages, as you know, they are extremely limited in Europe in the directive and European directive, and we will strictly stick to that as well. So there will be no more statutory damages than what is allowed according to EU law. That's only what I can answer. Other questions? Gentlemen? Yes.
Magnus Franklin from MLEX. Just a question on procedure. You mentioned this digital online...
Excuse me, I didn't understand the organization.
MLEX, sorry, I'm a journalist with a news agency in Brussels. On procedure, you mentioned the digital online provisions in this a lot. Have you negotiated this in the previous rounds, or is this something that is yet to be discussed in New Zealand or the future meetings?
We've touched upon the first part of the internet environment in the Mexico round, but not the second part, which concerns technological protection measures, etc. This has not been touched yet. It will be touched in New Zealand. Other questions? Yes, and then gentleman in blue.
About the question about the acquis, there is a small problem, at least as I can see it, is that when the April 1 directive was adopted, the term intellectual property was undefined. So the Commission published a document, for me it's a non-legislative document, which gives an impressive list of all IP rights covered by the directive. Okay. Do you consider this document as legally binding for the member states for the implementation? And have you looked at the real implementation in all the member states if they have implemented the list of all those rights in the 27 countries? I know in some countries like Spain or Greece, the term intellectual property is being seen as covering copyright and trademarks. And they use another term for industrial property, which covers patents. So what is the acquis? What is the scope of the current IPRED 1? Because for me, this document you publish with the clarification is just some kind of lobbying exercise or guidelines for member states on which rights are covered by the directive, but it's not a legislative document in itself. So I want to know what is the current status of implementation of this directive. Thank you.
Well, I don't think you will be surprised that I consider the documents published by the Commission as binding. This is the case. The Commission has published a document with a minimum list of rights, of intellectual property rights, which are covered by the directive. I have a copy here in front of me. And so, yes, I do consider that as binding. As to the question of monitoring the enforcement of the directive by several member states, I'm not sure this is the place to discuss that. I mean, it's not that I will refuse to answer your question. If my colleague Benoît Laurie of Internal Market wants to comment that, but this is totally different from my jurisdiction on ACTA. It's an internal market issue, if you want. Internal European law issue as opposed to an international negotiation issue.
Good morning. My name is Benoît Laurie, and I'm working in Internal Market Directorate. And regarding the state of play of the Enforcement Directive, as you know, all member states have transposed this directive, and the Commission is engaged into the evaluation of this directive. And we expect, the Commission expects to publish the evaluation report probably around summer or after summer.
Okay, gentleman in blue.
Thank you. My name is Dirk Poot. I'm a blogger from the Netherlands. It is my understanding that the treaty is to be effected as a plurilateral treatment, whereas the European Parliament has expressed that they would encourage you to expand the basis of the treaty from plurilateral to multilateral, allowing more freedom for the individual signing countries to leave out certain implementations of the ACTA agreement. Will you try to widen the base from plurilateral to multilateral? And the other question is, how many consumer advocacy groups or groups working on digital civic rights and privacy are currently partaking in the negotiations on ACTA?
Well, thank you for these two questions. The first question, will we try to have a multilateral base? Of course. I mean, the idea is that as many countries as possible would be good, because so we cannot force, of course, countries to join. So, by definition, it's on a volunteer basis. As to your second question, consumer groups participating, well, there is no private group participating in negotiation. It's handled by governments, but there's also no private industry groups. And industry groups has no more information, I'm talking of course from a European Commission point of view, than any consumer group. And the very reason is that we organize stakeholders meeting like this where we invite both, all stakeholders. So there is a strict equal treatment there. Thank you. Other question? We have 15 minutes left. But we can finish earlier, of course. Yes, Madam in green.
Yeah, thank you again, Eva Lichtenberger from the Legal Committee in the European Parliament. We have a very intense debate right now about penal sanctions and about the intervenience of European law in penal law on member states level. But enforcement mechanisms, as we will have also some obligations then in coming from ACTA, if it would be finished, then have to be done by the member states. So how will you run this process? And what is your mandate on that? Because this is very unclear. What will be the role, for example, for the legislation on European level and the enforcement mechanisms that you will member states ask to take?
Thank you for these two questions. First, on the negotiating guidelines, very clear. It's the presidency who negotiates on behalf of the member states, the rotating presidency, not the Commission. So it's not for me to answer further on that. The only thing I can comment, though, to your second question on the enforcement mechanism is that if you follow the point of view, the principle that nothing will change to the legislation because we follow the EU acquis, it's an irrelevant issue because there will be no need for new legislation in Europe. Thank you. Sir, yes?
Yes, thank you. I would like you to explain the institutional arrangements, the executive board that will be created, the flexible incorporation of new elements, how the, let's say I would call the Politburo of the ACTA agreement is going to work, and how it will go into the future, and how this will affect relationships in global governance between this executive board of ACTA with the WTO, the United Nations, WIPO, and those and organizations. And as well, I would like to know the relationship between if the countries that decide not to apply the agreements of ACTA will be placed upon the European Union's name and shame priority list for IPR non-cooperation.